Mandatory breath demand provisions of the criminal code, they're not going away after the Supreme Court of Canada did their thing yesterday. So yesterday, the Supreme Court of Canada refused leave to appeal to an appeal of the legality, the constitutional validity of the mandatory demand provisions of the Criminal Code of Canada that allow the police to pull you over and demand that you provide a sample of breath into an approved screening device, a roadside breathalyzer, a roadside breath tester, without any grounds, without any reason. So without a suspicion that you've been drinking and driving, without any reason to believe that you've got alcohol in your body, the police can pull you over and demand that you provide a sample into an approved screening device. Now, it's still supposed to be a lawful stop. We'll get to that in a minute. And it's supposed to all happen immediately. So the police officer is supposed to essentially walk up to your car, get your driver's license, confirm who you are, then make the demand and present that device to you immediately. And that is, it's always been mandatory in the sense that when a police officer has made an approved screening device demand in the past, you had to provide a sample. But there's always, prior to this, before this law was enacted in 2018, a requirement that the police had a suspicion that you had alcohol in your body. So the previous provision, remember, this is a warrantless search, so this is the police doing something without a warrant. They have to only do it when it's authorized by law, and the authorization in law is written into the criminal code. And the criminal code says, okay, if you pulled somebody over, you can go up to them and talk to them, get their driver's license, confirm who they are with their driver's license. And prior to this law being enacted back in 2018, the police, if they were talking to you, if they formed a reasonable suspicion that you had alcohol in your body, they could make a demand right then that you provide a sample into an approved screening device, roadside breath tester, breathalyzer at the roadside. Now, 2018, they changed the law, said that provided they pulled you over in a lawful stop, they've got the breathalyzer there and they're doing everything quickly, they still do it as immediately, then they could make this demand and you have to provide a sample. And if you refuse to provide a sample, there's very serious consequences. If you provide a sample and it registers a fail on that device, that's a system that we use in Canada that indicates that your blood alcohol concentration is in the prohibited range, 0.08 or above, and you blow a fail, then the police could detain you further. That is the provision that it arises as a result of one of those approved screening device demands. So, warrantless search. Normally you're free to be free from warrantless searches in this country, but this is a search that's permitted because it's written into the criminal code. But it's also a constitutional violation, actually many constitutional violations. So it violates your right to counsel. You're entitled to know about your right to talk to a lawyer, to have your that information conveyed to you upon detention. This is in the Charter of Rights and Freedoms, and for you to be able to talk to a lawyer. You don't get that at the roadside when you're pulled over by the police and they make an approved screening device demand. And you're entitled to be free from unreasonable search and seizure. So search is not based on a reason, reasonable and probable grounds. You're entitled to be free from that. But of course, the police in these circumstances had this provision written into the criminal code, despite the fact that there's these charter violations. Well, previously the court had said, well, okay, we can live with the charter violations here. Section 1 of the Charter of Rights and Freedoms will allow this to continue despite the charter violations because it's demonstrably justifiable in a free and democratic society. Okay, on balance, drinking and driving, bad. Want to be able to suss out people who are driving with a prohibited blood alcohol concentration, okay. And it's all going to happen fast, so it's minimally intrusive. So the court said on that basis, we're going to allow it. And we're also not going to allow the results of that test, the fail, to be something used in court to prove that you were impaired or over 80 milligrams. It's suspect evidence to start with, okay, because it's just an approved screening device and they can be wrong for about 1,000 reasons. But we are still not going to allow it to be used for anything other than a police officer to form reasonable and probable grounds. So, fine. That is something we lived with for the longest time. Then they wrote this new law into effect that says the police can just pull you over and make a demand. It's a different provision in the criminal code. It runs alongside of this one. And the police can just make a demand, what's called a mandatory demand, although they're all mandatory. It's called a mandatory demand. In those circumstances, you're required to provide a sample, and you're still facing all of the same potential problems if it goes awry. So if the police think you refused, if there was a problem with the device and they think that you're not trying to provide a sample, if you've got some medical condition, you're still facing a refusal charge and the potential criminal code conviction for that. And if you provide a sample and you get a fail and the police take you back to the detachment, you blow into one of their instruments there that's designed to measure the actual concentration of alcohol in your blood, and you blow nothing, there's no remedy for you. The devices can malfunction. We've seen that. There was an Abbotsford police officer who was testing it there on the roadside and he blew a fail. So you can get false fails, right? But we all lived with the old provision. The new provision came in. It has no reason for the test. And so we thought that maybe it was not going to be past that Section 1 requirement on balance, because there's absolutely no attempt to comply with the Section 8 standard of it being an unreasonable search and seizure. There's no reason for it in your personal circumstances. And our bigger concern was it can be used in such harsh and unfair ways and facilitate horrible police behavior. So when the police pull you over in Canada, they can pull you over for any reason, and they can pretty much make it up, because they can say they pulled you over to check your license, and they can say they pulled you over to check your sobriety, and that doesn't have to be because they saw you do anything wrong. They can just say they pulled you over to check your license and registration. And that is the doorway opening for abuse, because we see, particularly in the Lower Mainland of British Columbia, young brown men get pulled over. Is a big problem that I saw for the longest time. I've been doing this for 26 years, where they're pulled over, and the reason for the pullover is, just to check their license or something like that. And while they're pulled over, the police take that opportunity to try and shake them up, scare them a little bit, suss things out. Sometimes they think that they're doing something bad because they're driving a nice car and they're a young brown male. And then they're subject to a demand, and the police can certainly manufacture a refusal if they really want to. And there's times that it certainly seems that way from our perspective. And so we didn't like this. And of course, lawyers across the country, many of us had similar feelings about it. So when lawyers had clients who were convicted after using a mandatory demand provision, they challenged the constitutional validity of it. They said this is unconstitutional, not saved by Section 1. And the courts across the country universally have said, and I shouldn't say universally because not every judge, sometimes split decisions at appellate level courts, but the courts have said, well, yeah, it's constitutionally, it's not valid, but it's saved by Section 1 of the Constitution as a reasonable limit in a free and democratic society for those reasons that I explained. And then people thought, okay, well, we're going to seek leave to appeal to the Supreme Court of Canada. And the Supreme Court of Canada, we fully expected, would want to hear full arguments on this because it's a national interest issue. It is a search where you're compelled to participate in the police investigation. And everything's changed because now we punish people on the basis of approved screening device tests in this country in the administrative context. So in BC, you get a 90-day driving prohibition if the police say you blew a fail. And they just have to say you blew a fail, right? You'd like to think that it's a reliable fail, and you'd like to think that everything's square, but it's not. It's not always. Sometimes it is and sometimes it isn't. So we hoped the Supreme Court of Canada would want to hear arguments on this. And yesterday we got the decision. The Supreme Court of Canada can choose what it wants to hear. They can choose when you go and ask them to hear a case. They can say, three of us looked at it and we decided we don't want to hear it. We don't want to hear their arguments. And that's what happened. So the tough on crime people, can be very happy. And those people who think that anybody who's accused of drinking and drunk driving can be very happy. The Supreme Court of Canada did exactly what they want. Those of us who are worried about the slippery slope, particularly drunk driving law used as the lever to open the door to violate further constitutional rights, well, we're not very happy with that. And the fact of the matter is, drinking driving cases are one of probably the most in the country. Cases where people are wrongly charged, wrongly face prosecution because it has got the highest acquittal rate. And those are circumstances where you got professional witnesses, police officers doing it. very, very high acquittal rate for drinking and driving charges in this country. Lots of innocent people face it and have been saved because they had a clever lawyer and the courts recognized the problems and fallibility of the devices, machines, and the cases. So we wanted it to be heard. The big news, of course, is that the Supreme Court of Canada said, nope, they're not going to hear it. And so now the mandatory demand provisions are fixed in law, not going to change, going to be the same. And if you're pulled over, you make sure you do your best to provide a sample. And then after you blow, demand to talk to a lawyer because that's basically all you can do now.